afternoon and welcome. I'm Henry Weinstein, professor of the practice of law at UCI Law School, and it gives me a great pleasure today to be doing this program with Professor Rick Hasen, a Chancellor's Professor of Law here. I do not recall the precise date when I met Rick Hasen, but I recall very vividly when I sort of became, let's just say, intellectually joined at the hip with him. And it came during the day after the 2000 election, when it became clear that there was going to be a protracted legal battle over whether George W. Bush or Al Gore became the president. Rick had recently, or fairly recently, launched his election law blog, which provided commentary, documents, and other material that was absolutely invaluable, that was for anyone that was covering that protracted legal battle. And it was informative, and it reflected all kinds of opinions as well as documents. And since then, of course, his blog has become even more important. He's written several good books. He wrote a book called The Voting Wars, which is terrific. But today we are here to discuss Rick's book, which I highly recommend. Pardon me. As you know, my students know I love Post-its, and this it is. It's The Justice of Contradictions, Antonin, Scalia, and the Politics of Disruption. So I'd like to start out by asking Rick, why did you decide to write a book about Justice Scalia?
Well, first, thank you. Thank you all for coming, and it's great to be doing this again. And yeah, we were kind of phone mates for about 36 days.
Yes, 36 days.
Every day for hours.
Yes.
It's quite a time period. So why did I write a book about Justice Scalia? So about 6 years ago, I came up with a book proposal. I was going to write a book called The Scalia Court, and I was going to explain why Justice Scalia was the most influential justice. And showed it to some people, thought about it, and it really didn't gel. It was not there yet. Put it aside, worked on some other projects. And then a couple of years ago, a little over 2 years ago, I wrote to Dean Chemerinsky, and I said, Erwin, I think it's time to pick up the Scalia book. You have some time to meet this week. And he wrote me back 2 hours later and said, the justice just passed away. So it was February 13th, 2016. So then I knew I had to write the book because I knew that this would be the time to, at least the first chance, to take stock of his legacy. And so wrote that book, and the timing actually seems pretty good, given that with Justice Gorsuch on the court, as we might talk about, it might be that Justice Scalia will be more influential in his death than he was in his life.
Right. Okay. So in the book, fairly early on, you call him one of the most important figures in the legal scene of the last century. So why was he important?
Well, so there's kind of the book's called Justice of Contradictions, and one of the contradictions of the book is when we think about his influence. He was what David Cole of Georgetown Law called the most influential justice without influence in Supreme Court history. And what he meant by that was, if you think about how we typically measure the influence of a justice, one way we might say is, are they writing the most important opinions in the most important cases? And that was not Justice Scalia. So you think about the biggest cases, Shelby County, Citizens United. He didn't write those opinions. He wrote an important opinion involving gun rights, which we can talk about. Yeah. Most of his majority opinions were in the criminal procedure area, which was important in that area, but not all across. So he didn't write the most important majority opinions. He also was not the swing justice. So the time that he was on the court, he was not Kennedy or O'Connor or Powell, or the justices we think of as the ones in the middle who decide the really tough cases. I just saw a statistic that Justice Kennedy was in the majority 97% of recent cases. Pretty good batting average if you're Justice Kennedy. So how was Scalia influential? It was the sheer force of his writing and his role as a public intellectual. He was out there making arguments, and he made them in a way that appealed to law students and that appealed to law professors. So I write a case book. When I write the case book, of course I want to put a Justice Scalia dissent in there. It's going to make it interesting. I was just talking to my election law students about a 9-part test that Justice Breyer came up with in a case. I can't subject them only to that. They need, and Justice Scalia said he wrote his dissents to be pizzazzy. he was writing for the future. He was playing a very long game, and what he was trying to do was to influence the next generation of law students, lawyers, and judges. And I think if that's the measure, that's why I say he's proven to be influential. He's likely to be much more influential going forward.
Well, we'll get to more of that in a minute, but let's talk about the title of your book and what it means. It's called The Justice of Contradictions, Antonin Scalia and the Politics of Disruption. So the title alone seems to embody at least two themes. So tell us, what are the contradictions and just what was disrupted?
So let me start with the disruption first.
Fine.
So I argue that Justice Scalia did to the Supreme Court what Newt Gingrich did to the House of Representatives in 1994, coming in, shaking up that institution, changing the norms, making it a much more combative place, making it a place where the sort of usual rules no longer applied, and what Donald Trump is doing to the presidency. All of the norms out the window, different view. Now, of course, Scalia had, I would say, a lot more class and a lot more brain power, and was actually quite effective in changing the Supreme Court. He changed how Supreme Court justices talk about statutory interpretation. I think that's one of his biggest legacies.
Right.
He also changed the role of the justice as a partisan warrior, a public intellectual who's going to be out there. He's out there saying, I like my Constitution dead, dead, dead. You know, and this is this kind of in-your-face, I'm changing. This was a disrupting attitude. Now, what's the contradictions? I talk about a number of contradictions in the book. For example, he bemoaned the lack of civility, yet he was the least civil of all of the justices, at least in his written opinions. In his Obergefell dissent, that's the case establishing that same-sex couples have the same right to marry as other couples, he had a footnote where he talked about how if ever
I can give you the page if you'd like to quote it.
I know well enough. If ever is the price of a fifth vote in a case, I'd have to sign on to, and then he quotes a little of Justice Kennedy's flowery language from the Obergefell majority, I'd hide my head in a bag. He said, we've gone from the great writing of Joseph Story and John Marshall to the aphorisms of a fortune cookie. So bemoans civility, but yet is the most sarcastic justice, and I kind of have some measures of that. But the biggest contradiction was this, and one takeaway, what's the elevator speech, if we're just going up from the first to the third floor here, very quickly. Justice Scalia said that he had found the tools to legitimate what judges do. Apply originalism and textualism, originalism and constitutional adjudication. We're already at the third floor. Originalism and constitutional adjudication, textualism and statutory interpretation, and this was going to legitimate the Supreme Court's enterprise. But in his process of pushing this view, he actually delegitimated the Supreme Court by claiming that anyone who didn't follow his view not only was wrong, grievously wrong, as he would sometimes say, but that they were not acting as judges, they were acting as politicians, they were acting as super legislators. And in the end, the message he sent was that the judges on the court were politicians, which is precisely what he said he was trying to avoid.
Right. So the question, one of the other questions seems to be embodied in this is something that you address, which is the question about allegedly value-neutral judging. Now, to put Justice Scalia in a little broader context, when Justice Roberts had his confirmation hearing, he famously said the role of a judge was to call balls and strikes, whereupon your friend, election law and constitutional law scholar Pamela Karlan promptly responded, no, that's not the role of a Supreme Court judge. The role of a Supreme Court justice is to define the strike zone. So what is the proper role of a Supreme Court justice?
Well, I think that issue is debated, and I think what I try to show in the book is that Justice Scalia was no different than every other justice in that his value judgments sometimes affected how he decided cases. And the one way I show this is that he set forth neutral, so-called neutral rules of interpretation, and he didn't always follow them. Sometimes he pulled a rabbit out of the hat. Sometimes he ignored his usual rules of interpretation, and usually, but not always, it led him to a result that was in line with his admittedly very socially and politically conservative views. What was different about Justice Scalia was that he claimed he was better than everybody else. He claimed he had found he had defined the strike zone. He could call balls and strikes, and not only that, he could tell everybody else how to call balls and strikes, and they'd all call them the same way. And that was a very high bar. He didn't live up to it, and I think that was the main failure of the process so far. And in fact, if you look at the main critiques of Scalia from the right now, it was that Scalia was not Scalia enough, and that he had actually properly defined the strike zone, gave us the tools to call balls and strikes, but he didn't have enough strength of conviction to actually pull the trigger, the way someone like Justice Thomas, and I would say probably likely to be Justice Gorsuch, is going to be more likely to do. So we can debate what the proper role is. That's not what I was trying to do in this book. What I was trying to do in this book is show that Scalia's attempt to define the role of the judge and to apply that definition to how he decided cases was not successful.
Right, but even he, at least on one occasion, acknowledged the limitations of this approach. In 2008, he was interviewed by NPR's veteran Supreme Court correspondent Nina Totenberg, and he said, "I'm an originalist and textualist, but I'm not a nut." What did he mean by that?
He meant he wasn't Clarence Thomas. But what he meant was that sometimes he would do things like apply settled precedent. So that was a rabbit out of the hat. He had the means of interpretation, but sometimes he wouldn't follow it. And there wasn't a consistent way in which he would do this, when he would decide to apply precedent, when he wouldn't. But just to give you an example, since we have a room full of law students, something that I haven't talked to my general audiences about, but substantive due process. You've all heard of it, I hope, by now? Okay, so he hates substantive due process, right? It's the abortion cases, it's the same-sex marriage cases. Terrible way to decide cases, except after the Supreme Court in the Heller case recognized that the Second Amendment of the Constitution contains an individual right to bear arms, we could talk about that opinion, there was a follow-up case, a case called McDonald, which was a case which asked the question, does the Second Amendment apply not just against the federal government, but against the states? Now, there was a tremendous effort behind the scenes, which I describe in the book, of conservative legal advocates to try to get Justice Scalia and Justice Thomas to find the right to bear arms in how it applied against the states in the Privileges or Immunities Clause of the Constitution. Remember, that's
right.
The part when your common law professor says, oh, you don't need to worry about this. In 1873, Supreme Court said this was a dead letter. Justice Scalia, at oral argument when Alan Gura, the lawyer for the gun rights side, is making this argument, Scalia says, what are you, a law professor? Are you going to score more points for making this argument? Let's just take substantive due process and move on. And in his opinion in McDonald, it's literally one sentence. Oh, I'm just going to apply substantive due process. Justice Thomas spends 53 pages describing everything from how Thomas Jefferson raised his children. I mean, it goes on and on and on to try to figure out what the Privileges or Immunities Clause means. So sometimes precedent mattered, sometimes it didn't. Sometimes originalism gave way, sometimes it didn't. And sometimes there were good originalist arguments that were made on the other side, and he simply chose not to respond to them. If he had a good response as to why originalism wouldn't lead him in a particular direction, and we could talk about those cases if you want, he would simply ignore it. Sometimes he wouldn't sign Justice Thomas's originalist opinion, and he wouldn't explain why. So not a nut, okay, so he's going to let other values come in, but he had no principled way, no description of when that would be.
So speaking of that topic, why don't you talk a little bit about his approach to affirmative action and what some of the intent of the post-Civil War amendments to the Constitution were? Sure.
So let me just to give a little bit of background. As I said, Scalia's approach to constitutional interpretation was originalism, and his approach to statutory interpretation was textualism. Textualism, when it comes to statutory interpretation, looks just at the words of the statute as they would have been understood by an ordinary English speaker at the time that the statute was written. And in order to understand what it means, he would often look to dictionaries from the time. Sometimes he would pull out canons of construction, like how do you read a comma in a particular context? I mean, really, what's the role of the semicolon? I mean, things, very, very technical ways of reading things. When it came to originalism for the Constitution, he had a somewhat different approach. Original public meaning looked not only at the words, although the words were central, he also looked at how things were socially understood at the time. So, the Equal Protection Clause, 14th Amendment, talking about the 1860s. What did the Equal Protection Clause mean? Well, Scalia famously said, sex discrimination, that couldn't be protected by the Equal Protection Clause because Nobody at the time that the 14th Amendment was ratified would have understood it to extend to equal rights towards women. So that's not just a textual reading. That's not just saying, what do the words equal protection mean? It's saying, how did people in 1868 think of equal protection? And yet, when it came to why he declined to accept affirmative action laws as permissible under the, against an equal protection challenge, he said, look, I can read the words. The words say equal protection. This is not equal. Giving preferences to someone because of their race is not equal. And yet, at the time that the Constitution was ratified, Congress passed laws giving newly freed slaves, African Americans, special privileges. So if you want to understand what the social meaning of the Equal Protection Clause, that was not seen as violating the Equal Protection Clause at the very time that the Equal Protection Clause passes. So maybe Scalia didn't know about this. Can't say that, because one of his clerks, Scalia used to hire, sometimes he'd hire a liberal clerk called a counter clerk. He said he did it to keep him honest and make sure he was dealing with all the counter arguments. Scalia had a clerk who's now a professor at the University of Michigan, wrote him a memo when one of these cases was pending and said, here's all this historical evidence that suggests that affirmative action, what we today call affirmative action, was acceptable at the time of the ratification of the 14th Amendment. You may disagree with its application. You may want to apply a purely textual reading, but you should at least explain yourself and why all of this historical evidence doesn't apply. Not a word. And when a similar argument was raised by Jeff Rosen, the head of the National Constitution Center at a dinner party with Scalia, his response was, oh, well, no theory is perfect. And he often deflected when he would be called out in public settings, why aren't you following this originalist view, why aren't you following that originalist view? He would make a joke. And so that was his way of dealing with it. He never fully grappled with it. I think this was another one of his contradictions. He said he welcomed debate, and yet he often avoided debate. One of the things I found in my research is that there was a letter from Scalia to the University of Chicago Law Review. They had written to him and asked him, would you like to review Yale professor Jack Balkin's book, Living Originalism? And Scalia wrote back, which is a book that takes a very different, much more left-leaning approach to alive Constitution. Yes, very much. And Scalia wrote a letter back and saying, I'm sorry, I don't read any criticism of our work. Since I don't read it, there's no way I could review the book. And he concluded, he said, I will quote Benjamin Disraeli's maxim, never complain, never explain. Well, he complained a fair amount, but he didn't do a lot of explaining when he was called on these things.
So since you were just talking about the post-Civil War amendments, I know that Scalia was not the primary writer, but I think we should at least talk about a couple of the cases that he didn't write in because he voted in a particular way. And I'd like to start with the recent important voting rights case called Shelby County versus Holder. So could you talk about that a little bit and how it fits into the Scalia framework?
Sure. So in 1965, Congress passed the Voting Rights Act. It did a number of things which enabled African Americans to register to vote and actually vote in the primarily American South, but there were problems all across the country. And one of the provisions that the law contained was something called the preclearance provision. Section 5 of this act said, if you were a state with a history of racial discrimination in voting, before you can make any changes in your voting rules, you had to go to the Department of Justice or to a 3-judge court in Washington, D.C. and get federal approval. And you had to show that the law would not make protected minority voters worse off. So this was meant to stop things from getting worse. Because what happened before Section 5 is the federal government would come in, sue over a voting practice, they'd win, then the state would enact a new discriminatory voting practice. This was meant to shift the burden of proof. The Supreme Court, in a case called South Carolina versus Katzenbach, said this was constitutional. It's strong medicine to require states to have to do this, but given what they had been doing in terms of voting rights, it was acceptable. It's okay. And the Supreme Court repeatedly said, as Congress renewed the preclearance provisions, that this was just fine. The most recent renewal came in 2006. Congress renewed it for another 25 years, and they didn't update the coverage formula for deciding which states should be covered.
And the vote was?
So the vote was 98-0 in the Senate in favor of this law, which Scalia said was immediately suspect, without pointing out that the vote for his confirmation was also 98-0. But the law passed with another 25-year, and the Supreme Court, in an opinion written by Chief Justice Roberts, who has his own very interesting views about race and the Voting Rights Act.
That's as neutral a word as you could use.
Yeah, interesting views.
Yeah.
Not my views, but interesting views. He wrote an opinion that said that subjecting states to this preclearance provision without updating the coverage formula to take into account newer data about which states were engaged in intentional racial discrimination would violate the equal sovereignty of the states. What part of the Constitution is that in? You'd have to talk to Professor Lippman, who wrote an excellent article in the Michigan Law Review explaining that it's nowhere in the Constitution. It is a judicially created doctrine. And so for someone who is...
More difficult than finding a needle in a haystack.
Well, the Supreme Court could find whatever it wants in the Constitution. I mean, that's how these things work. But for someone who'd be committed to original public meaning and to the words of the Constitution, it was some new thing. Why can't you subject some states to different rules if those states have a history of engaging in discriminatory conduct? I'm not aware of any part of the Constitution that would prevent that from going. But now we have this new doctrine that judicially created. It comes at a time when Justice Scalia was complaining about the loss of popular sovereignty with the Supreme Court overturning anti-gay rights measures, anti-same-sex marriage rules. Comes at this time, the courts, and he's saying, what about the democratic process? Why shouldn't we listen to what the people want? And yet the Voting Rights Act amendments overwhelmingly approved in Congress, not subject to any deference.
And why was a 98-0 vote suspect?
What he said was, he said in the, back in the time of the Talmud, the Israeli Sanhedrin, which was this medieval judicial body, they said that you could not have a unanimous imposition of the death penalty because it would mean that something was suspect about how it happened. What he claimed was, and he said this at oral argument, and there was literally a gasp in the courtroom when he said this, he said the reason the Voting Rights Act passed on these lopsided votes was a phenomenon, I'm quoting him, it's not me, a phenomenon known as perpetuation of racial entitlements. That once you pass a law that benefits a racial minority, then it's impossible to get rid of it because they have too much power. This was a theme that Scalia raised. He was all for the political process except when it came to the rights of racial and ethnic minorities or to gay rights. He also said in one of the gay rights cases, well, gay people they don't have kids, they have lots of extra disposable income, so they have too much political, well, I didn't say too much, they have disproportionate, was his word, disproportionate political power. And so therefore we have to be suspect of that too. So he was all for letting the political process run its course, except when it tended to not go in the ideological direction that I think he favored.
Well, let's also talk just even briefly about about issue framing, because as you know, and I know you've discussed with your students how you frame the question is, so the term racial entitlements. Some people talk about when Congress passes something like Social Security, Medicaid, something like that, that's an entitlement. Voting is an entitlement?
Well, so you said it's a racial entitlement, it's a special privilege. And so I guess the special privilege would be that people who live in states who are racial minorities get extra protection from the government so that they're not discriminated against. It's not a theory I would defend, and I think there's a good reason why there was a gasp in the courtroom when he made the remark. It was like the time in one of the cases involving affirmative action where he talked about really competent blacks, again, his term, not mine, who should go to, it's this mismatch theory, which we can get into, but should go to lower prestige schools because they will be more successful. I mean, he said that he stopped reading the Washington Post a while back because it was so liberal. And he listened to talk radio. And a lot of, in his later years, a lot of what he said reflected this kind of, I would say, populist, anti-elitist, nationalist, neo-Trumpian worldview. He was Trump before Trump in some ways. Although I hate to make that comparison because he was so much smarter and so much more effective. But in terms of the ideology, go and read his opinion involving the Arizona SB 1070, the anti-immigration law. It could read like something that was written by Trump. Hordes of immigrants are coming over into Arizona. They're threatening the lifestyle there. They're taking their jobs. They're changing things. I mean, it really was In his last years particularly, he was kind of came across as feeling like he was the last one on the court who could protect America from these Ivy League elitists who were going to ruin everything. And of course, he's a Harvard Law School graduate who had a vocabulary that was just,
off the charts,
astronomically advanced compared to the average person.
Right. So perhaps his most famous majority opinion is the Heller gun case. Could you talk a little bit about that?
I can. So there was a question as to whether or not the Second Amendment gives an individual the right to bear arms. I'm sure you've all heard about this, or whether it was just meant to protect the right to form militias and not this individual right. Some believed, as Justice Stevens said in his dissent, that the Supreme Court had already settled this case decades earlier. But eventually the case gets to the Supreme Court, and Justice Scalia writes a majority opinion, as I said, outside of the criminal procedure area, probably his most famous and important majority opinion, where he says he is applying originalist methodology to find this right to bear arms. That it's an individual right, which means that someone can sue. If the state passes a law that imposes gun control, someone has standing to sue and claim that this is a violation of rights, just like if the government says you can't speak, that would be a violation of your First Amendment rights. The opinion was interesting for a few reasons. I'll mention two. One was, although Justice Scalia claimed in an interview that this was his most thorough originalist opinion, one of the ones he was most proud of, it did a lot of things that were not originalist. For example, looking at post-ratification history, looking at social policy, talking about how dangerous it might be to have these laws. And so there are people on both the left and right. I'd point to Nelson Lund, who's a very conservative professor at now known as the Antonin Scalia Law School, used to be George Mason, as well as Lawrence Tribe and Joshua Matz, as well as Barry Friedman. They've all made the argument that what Justice Scalia actually did in the opinion was a better example of the living constitutionalism that Justice Scalia said he hated than pure originalism, because he was looking at all kinds of sources other than just originalism. But the other thing that's really interesting about the Heller opinion is that there's a paragraph in there which says something like, I'm paraphrasing here, we're not saying today that laws against felons owning guns or the mentally ill or it's the laws against owning bazookas are unconstitutional. It's going to be a balancing. This is the part that Lund thought was the biggest problem. Right. I guess he believes that anyone should be able to own a bazooka, right, regardless of whether they're felons. I mean, I don't know exactly where Lund would draw the line. But he put this paragraph in there, and that paragraph has proven to be the most important part of Heller, because virtually every gun control challenge has failed in the lower courts, citing this paragraph, doing this balancing. And the Supreme Court has failed to weigh in again, leading Justice Thomas, maybe about a month ago now, to write a dissent where he said, he called the Second Amendment an orphan and said the Supreme Court's abandoning it. He said, we wouldn't not take up a case where someone was completely cut off from getting an abortion or someone was completely stopped from being able to speak. These would raise constitutional questions this court would take up. And somebody asked me at another forum whether I thought Scalia would have signed on to that dissent, which makes me wonder, did he write that paragraph, or did Justice Kennedy insist on that paragraph, or someone else on the court? I have no inside knowledge of how this was, but it turns out that Heller is the best friend of gun control we can have. Because first of all, it neutralizes the argument, the Supreme Court needs to recognize this right. And then it provides a balancing test that has allowed all of these laws to be upheld. In fact, just last week, I think it was, Justice John Paul Stevens, the dissenter in Heller, who made the argument in dissent that originalism did not lead to finding a constitutional right to same-sex marriage. He wrote, Stevens wrote an op-ed, age 97. I wish I could live that long to be able to write an op-ed in the New York Times at age 97. Wrote an op-ed in the New York Times saying we should repeal the Second Amendment, which is the most counterproductive thing I can imagine. That's the last thing you would want if you like gun control is a campaign to try to repeal the Second Amendment. Things are great now when it comes to what the Supreme Court's saying about guns. The problem is, if you like gun control, the problem is a political problem. It's not a constitutional problem. That may change if Justice Kennedy retires this spring. But right now, the Supreme Court's not the impediment, and this would just have stirred up some of the muck.
Right. So you have said a couple of times now that besides Heller, he wrote a number of important opinions in the area of criminal procedure. One that immediately leaps to mind is Crawford versus Washington, that involves a confrontation clause. And it seems like the at least that one maybe is the most consistent with his espoused doctrine. So could you talk a little bit about the criminal procedure cases?
Sure. So one of the problems I had in writing this book is I'm an election law person. And so I was really out of my element when I'm writing about the religion cases, which I don't teach, or writing about criminal procedure, which I really don't teach. So one way I tried to solve my ignorance problem is I sent drafts or chapters to different people who actually know this area of the law, which was somewhat helpful. And so Professor Natipov, who was my colleague and is now again my colleague, gave me comments on the book. And she said, you know, the confrontation clause is really interesting, but it's really unimportant in the real world of criminal adjudication. So the confrontation clause says that at trial, one has the right to confront witnesses against himself or herself. And this right is one that applies anytime someone has made a certain kind of testimonial statement to law enforcement that could be used to find someone guilty of a crime. And he made it, it's a really original argument, goes back to Sir Walter Raleigh and talking about why in England it was a problem when people could not confront their accusers. But what Professor Natipov said to me, she said, you know, it's great recognition of a criminal defendant's constitutional right, but so few cases go to trial in the United States, so few cases actually lead to witnesses being confronted, that actually had a much smaller practical effect than Scalia's views in the Fourth Amendment area, where he also sometimes found things to be searches, that is, for example, GPS devices or thermal imaging devices, where others would not necessarily find them to be searches. And I think Justice Scalia's defenders always say that he didn't just decide cases in line, or he didn't decide cases in line with his ideology. He followed the law wherever it would take him. And the strong evidence of that are his confrontation clause cases and these Fourth Amendment cases. In other areas of criminal law, he was extremely harsh. And for example, he dissented from a Supreme Court case which said that the cognitively disabled could not be executed. He thought it was perfectly fine to execute what he called the mentally retarded. He thought people who were convicted of crimes as juveniles could be executed. He was a huge supporter of the death penalty. He didn't believe very much in the exclusionary rule. He was not a friend of criminal defendants in most areas, but there were some cases that were at least somewhat helpful to criminal defendants.
Right, okay. So before we open this up to I'm going to go back to one of the bigger picture questions you were talking about at the beginning. So the late Justice William Brennan is famous for saying the most important word around the Supreme Court is 5, meaning the number of votes that you needed to prevail on your side. And he was famous also for, doing a lot of persuading, cajoling colleagues in private and stuff like this. This seems to be very different than the approach that Justice Scalia took. As you quoted the bag over the head case, but it's also, there were numerous instances in which one could cite that he criticized his colleagues' work, and one sort of wonders, did he ever think that maybe really being nasty to whoever was, Kennedy or Connor or whoever, that it would matter in some future case where he might want a 5th vote that he might be likely to get? That doesn't seem to have been part of his calculus.
Well, so I tried to look into this question of whether or not Scalia ever lost a majority by his acerbic comments, and especially how he treated justices like Justice O'Connor, to whom he was very dismissive, called her opinions irrational, really, I think not showing a lot of respect to Justice O'Connor. There was one example that some people cited involving an abortion case, but I could not find any evidence, and in fact, people who have looked at the documentary evidence could not find evidence. The most you could say is that he could not convince Justice Kennedy to change his mind in that case. This is the Planned Parenthood versus Casey, very important abortion case. The unanswered question is whether he would have gotten more majority votes and been able to write more opinions if he was not so acerbic. He claimed in a 2013 interview, of course not, it makes no difference, these issues are too big, nobody's paying attention to Scalia. That's kind of what his attitude was. But I think it's impossible to know. But another way of understanding what Scalia was doing is that he was really playing the long game. That what he wasn't doing was trying to Brennan wanted to get the law changed now. He was on a court that had fewer liberals than conservatives, but enough swing justices they could sometimes pull one in a creative way. Scalia was on a court that was conservative mostly, but not on the issues he cared about the most, like the social issues like abortion or same-sex marriage, and not conservative enough that he could be pulled, that he could pull everyone further to the right. I think he moved the middle of the court, but his goal was to create a kind of intellectual structure that would allow the next generation of justices and judges to be able to use his methodology to really lurch the court to the right. And I think that's precisely what's going on now. So if you look, Scalia was one of the founders of the Federalist Society. You look at his role in the Federalist Society in terms of getting originalism and textualism to be taken as orthodoxy. That didn't exist before Scalia. Scalia made that with others, but he was the prime mover. He was the big public spokesperson for this, not Thomas, even though Thomas applies it. Scalia was the one out there. And now Trump comes in as president and says, I'm picking from this list of my Supreme Court justices. And who created the list? The Federalist Society and the Heritage Foundation. And where are the lower court judges coming from? They're Federalist Society judges. Neil Gorsuch, the newest Supreme Court justice, gave a speech, and he said, this shows that you could be a committed originalist and textualist, and you can get confirmed to the court. And so this is what I mean when I say that he was playing the long game. Scalia was setting out something that would exist far beyond his lifetime. And if he gets enough, it depends on who's the president and who controls the Senate, if he gets enough additional justices on the Supreme Court, the court's going to look much more like Scalia thought that it should look than it did look at the time when he was a member of the court.
So generally we say that someone's impact can't be measured until we've had more time to measure the impact, but it sounds as if at least your early stage conclusion would be that this is a guy that had a much bigger impact than his majority opinions.
So when I went to Irwin, I said I want to write this book. Irwin's first reaction was, I don't think we can really know a justice's impact until 50 years after they're gone. So you can only speculate. And I say in the book that this is my view at this point in time. 2 years after his death, where are things going to go? What I do say about him, I call him, the opening line of the book is, he was a polarizing justice in polarized times. That he's not going to be universally admired, or mostly universally admired. Think about Oliver Wendell Holmes. At least people who don't know about Buck versus Bell think great justice, right? Or Brandeis. There are certain justices,
right.
John Marshall. He's not going to be that because he was a product of and a participant in the polarization of the American political process. And so, and the American judicial process. And so he's going to be loved by some and hated by others. And it is too early to know exactly where things are going to end up, and how much influence the Scalia view has is really going to turn on how many Republican presidents and Republican senators get to appoint judges who model themselves like Scalia onto the federal bench. So far, they've had a pretty good record of getting those judges on the bench. So even if Trump didn't appoint another judge, already some circuits now have judges in their 40s who are going to be on the court for 20 years, 30 years, 40 years. Neil Gorsuch turning 50. Life expectancy, that's a long time to have a seat on a body where you basically can't be removed.
Right. So one other thing just in terms of his role, Supreme Court justices historically have been known to be reticent about being in public. There are some Supreme Court justices, I believe it was Powell, who canceled a graduation speech at Davis because it was going to be filmed, and the whole idea was that Supreme Court justices should not be out in public, they shouldn't be making speeches and stuff like that. That seems to have changed dramatically in recent years, and he seems to have been one of the forerunners of that.
So one thing I could say is that in the 1960s, there were justices who did appear in public. William O. Douglas, very flamboyant Supreme Court justice. Wild Bill
as he was known.
I don't know if any of you know, like up in Oregon, the Pacific Crest Trail, that's Oregon and Washington. He would take a hike public hike. Anybody could join him. Wouldn't it be great to go hiking with a justice? He used to give speeches about in the West, environmentalism. Justice Goldberg, who used to be a politician, gave speeches about anti-Semitism. They weren't really talking much about the court. And then in the 1970s, things quieted down. Scalia comes on the court, and he's making speeches. And he makes a lot of speeches where it's not just anodyne, I wrote a new book on this, and here are my 6 theories of whatever. He is really in your face, telling people who complain about Bush versus Gore, get over it. It was one of his famous lines. And I think he created the role of the justice's gladiator. So we've got the Federal Society, we've got ACS. The conservative justices appear at the Federal Society, the liberal justices appear at ACS. I actually blame Scalia in part for Justice Ginsburg's very unfortunate decision to make arguments against Donald Trump in the middle of the election. That was a really not very good thing for her to do, because there could have been a Trump versus Clinton legal challenge that could have gone to the Supreme Court, and there would have been calls which I think would have been justified for her to recuse herself ever having made those remarks. But you kind of get in your head. I'm notorious. I can do what I want. My trainer has a book. There's a children's book. So I really think that he kind of opens it up. Scalia, talking to Brian Lamb on C-SPAN, talks about how his bobblehead is the most popular. I said, maybe it's being used for target practice. I don't know. Like a bit of false modesty.
Well, let's open it up to the audience. Questions? We have a great opportunity here. Yes, right here.
I think we need to bring a mic over.
Okay. Oh, yes.
Thank you for sharing your book with us. Would you have had enough material if Scalia hadn't passed away? Do you think you would have still gone ahead with your book? Was there everything that you needed? Tell us more about that.
So my book is not a biography. I never met Justice Scalia, and one of the things I don't know if you asked me, Henry, or someone asked me, is I don't talk a lot about the Catholicism of Justice Scalia and how much it influenced him. I didn't try to get into his head. What I was trying to do was I was trying to ask, what influence does he have? What will his legacy be for American law? What were his theories, and how likely are those theories to continue? So I think I could have written the book had he still been alive, but I think now we have the full record, and so it's easier to take stock. One of the things I start the book with is the end of the Supreme Court's 2015 term, where the Supreme Court decides both the Obergefell case on same-sex marriage and King versus Burwell, which was the case that upholds this Obamacare provision about federal exchanges established by the state and how all that's going to work. One was seen, he saw them at least, as a failure of originalism to be accepted in Obergefell and a failure of textualism to be adopted in Burwell. Now, there was a textualist argument in Burwell. He just didn't, that made by the majority, but he didn't agree with it. But it was kind of a nice capstone to be able to do it. I think the book coheres more because people would say, if he were still alive, you don't know where it's going to go. So I think we know. But he was on the court for nearly 30 years. There was plenty to say about him, and it was pretty baked in terms of where he was going. He wasn't one of these justices that was evolving on the court, as they talk.
Yes, back there.
So you mentioned his departures from originalist and textualist orthodoxy in favor of conservative legal or policy outcomes. What impact do you expect that to have on his legacy? Are his followers more consistent in terms of applying originalism and textualism, and are they following his sort of departures? And how do you see that affecting his legacy?
So the biggest criticisms that I think I mentioned of Scalia are that he was not consistent enough as an originalist or a textualist. So for example, I talk about a case, really obscure case, called Green versus Bach Laundry, which is a case about Federal Rule of Evidence 609. And they use the term criminal defendant and how do you apply this in a civil case. Very mundane, not the kind of case that's going to appear on the front of the New York Times. And Justice Stevens writes this majority opinion where he goes through page after page of legislative history, which was, of course, Scalia said legislative history couldn't be relied upon, was not valid, was not accurate. Scalia, though, concurs, agrees with Justice Stevens to how to read the statute, but he does so by pulling a rabbit out of the hat. He said, well, when a statute's absurd, we can rewrite the statute. And he simply rewrote the statute. And so he's been criticized for doing that. I think someone like Gorsuch is going to be less likely to rewrite the statute. You know, the frozen trucker case, which you may have heard about, Gorsuch, you know. Oh, sorry. He wasn't operating his vehicle. He wasn't not operating his vehicle. He was operating his vehicle by driving it to safety so it wouldn't freeze to death. Sorry, he loses. I think there's kind of a harshness there. Although, the other thing that I've noticed that's happening is, you know, Scalia is this originalist. Originalism has become such, I kind of chart the rise of originalism. It's kind of exponentially increased in terms of its prominence in the law reviews and in cases. But there's lots of different views of originalism, not just the Jack Balkin kind of originalism. Stephen Calabrese, who's one of the founders of the Federalist Society, has written an originalist case for same-sex marriage, which Justice Scalia absolutely would have disagreed with. If originalism becomes that capacious that it can find a right to same-sex marriage in the Constitution, then it's going to be no different than the living constitutionalism that Justice Scalia hated. So it's really hard to say exactly where things are going to go. I think when push comes to shove, any judge, any justice applying a set of rules to a difficult case is going to bend. And I think that sometimes is appropriate. I think in the frozen trucker case, it would have been appropriate to bend if there was a way to do so and achieve justice. What is different about Scalia is he never acknowledged when he was bending that he was doing something inconsistent. Instead, it was, oh, well, this is another tool. Sometimes I rely on precedent. Sometimes I have this absurdity exception, as opposed to saying, I'm not applying my methodology in this case.
Over here. So let me ask one more question in the absence of there being another one from the audience in a moment. So is he really an original? Was there any justice before him who claimed to have this consistent, coherent of philosophy, somebody earlier in the 20th century, the 19th century?
Sure. So there were justices, you can look over time, and I'm not an expert on the history of originalism. There are some great books out there, and there's a book coming out by Eric Siegel, which does a very good job tracing the history.
He wrote a very good review of your book.
He did, which I appreciate. Hugo Black is one who is often thought of as an originalist. What was different about Scalia's originalism was that lots of originalist theories looked at original intent. What did the founders think? So there's this great moment in oral argument in a case involving whether California could ban violent video games so teenagers couldn't buy them, where Justice Alito, who's very conservative, almost always voted with Scalia on results, but was not an originalist, Justice Alito says in this oral argument, I think what Justice Scalia wants to know is what James Madison would have thought of video games. Would he have liked them? And Scalia says, no, that's not what I think. I would ask whether anyone at the time of the founding of the Constitution would have thought that there was an exception to the First Amendment for speech about violence. And it's not about what the founders intended. It's instead about how the words would have been understood by an ordinary person at the time and what within the social context. So that was different than getting an intent. But if you're going to not just look at the words, as he does with textualism on the statutory side, if you're going to look at social context, you've got two problems, right? One is you've got a history problem. You know, we talk about law firm history. Judges are not historians. They often get the history wrong. But now they have to be armchair sociologists, too, and figure out, well, what would people have thought at that time? I mean, it's so hard to know what people think today about certain things and to actually come up with a single way of that. I mean, what we come down to is you pick out the evidence that's going to support your side. That's what he said that people who looked at legislative history did, but I think it's not better to be arguing about whether you should look at the third dictionary definition in Webster's or the fourth dictionary definition in Random House, and this is sometimes what it comes down to.
And on that point, just before we end, there's one example in the book about, I think there was one passage that he focused on, one passage of a small amount of words, and I believe a law that ran for 2,700 pages. Could you talk a little bit about that?
So this is the King v. Burwell case, which I talked about a little bit before. This is the case involving whether people who were living in states that did not create state exchanges for Obamacare, they did not want to participate in that process, but those people could get their health insurance through a federally established exchange. And the question was whether people who were in those states could get subsidies that the federal government provided to people who participate in programs, quote, established by the state. I think John Roberts, the Chief Justice, did a pretty good job making a textualist argument that if you read these words in context, established by the state could include federal exchanges. But this was, to Scalia, the absence of a principled approach to law. He accused the justices of having favorites in the law. They liked Obamacare, which is hard for me to believe that really applied to John Roberts or Kennedy. And he didn't care about consequences. Right? In that Bach laundry case, he said, oh, well, it's going to lead to an absurd result where civil defendants but not civil plaintiffs can exclude certain character evidence. But here, the testimony was that if you got rid of these subsidies, that the law would go into a death spiral and the American healthcare system would collapse. Scalia didn't care about that. To think that Congress would have intended this absurd result is a little crazy. But yet, he was willing to let the chips fall they may in that case. And I think it once again illustrates that Justice Scalia, like all of the other justices, sometimes let his values interfere with how he decided cases. That's fine, but just if we owned up to that and we recognize that justices do that, I think we'd have a great appreciation of what the Supreme Court actually does rather than what some of the justices say that the Supreme Court does.
And on that note, thank you very much.
Thank you.